But it's, again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome to the Think Tank. So, hey, Douglas, Mexi, good to see you guys. So, we're going to go over the recusal request. Now, this is going to be, it says defendant's motion for recusal and disqualification of Justice Beverly, and I think it's pronounced Cannone. So it's looked to me like there's, you know how it goes. Lately, it's just like, get rid of this judge. So, this case, oh my God, it's snaky, you guys. It's just, I don't know how they would ever in a million years be able to convict this woman. I mean, I suppose everybody's going to have their own opinion. Well, of course they are. But, this is just one of the more sus cases that I have seen. It's just like, oh my God. Yeah, there's a lot that's going around trying to get rid of judges and attorneys. Yeah, exactly, Mexi. Chad Daybell's lawyer wants out as well. It's just like, what? And then we just finished doing an update from Delphi where they're in the Supreme Court right now trying to see if the judge should go, if the lawyers should go. I mean, it's just a freaking mess. So again, there's this. Let me see how I can get I think I can do that. So this case here is a lady by the name of Karen Reed, who is being charged with backing over her boyfriend, who happens to be a cop. And she's fighting this. Now, I don't have them set up right now, but yeah, her boyfriend. It doesn't look personally to me like she was backed over, like we're trying to say, or hit. It looks like he's beat up and thrown in the yard. And also, it looks like he was chewed on. Yeah, the guy in the snow. Looks like his arm was chewed on by a dog. So the dog's name is Chloe. And after this happened, they're saying that Chloe may have bitten somebody else, maybe a couple others. But we don't know where Chloe is, which is the most bizarre thing ever. Like, what? They didn't question. Okay, he was at this place. They were pulling up, supposed to be like after the bar kind of get together. His girlfriend, which is Karen Reed, drops him off at this party that's full of people that are all connected somehow to the cops. And they say he didn't make it into the house. I don't know about that. So there is so much to this case. It would take me like all day to even give the basics. So I'm just trying to get a little bit out as I can because this trial is set up for March 12th, if it happens, for March 12th. So, ooh la la. So you know how I like to do things a little bit organically. I have not read this yet. I get the gist of it, obviously. Let me get comfortable here. Sorry, guys. Oi. I pulled something moving my furniture last night. It's like, what? Yes, exactly, Douglas. Fractured skull. So they're saying that fall, in their eyes, looked like he had fallen like 3 stories, which suspiciously is basically how high this house is. Whether there's a way, I don't know. I haven't seen the interior of this place yet, which they happen to have happened. They put all new carpeting downstairs where they assume this get together happened and sold the house and gotten rid of the dog. So a lot of very suspicious things. Watch my previous live on the dog bite expert. He's a dog trainer and he would train them to bite. So this was an interview or a talk that attorney Melanie Little had with this. His name's just right now. Let's see here. Let's just see here because I want to get it right. So I think it's Garrett, but let me look. I don't have his name on there. How odd is that? But you know what? Check it out. That's what I think too, Douglas. I think he had a fight inside of that. That's what it looked like. They even said that his knuckles were banged up. And that's the thing. Yeah. First rule of a fight club. Don't talk about the fight club. Okay, so this is a fairly long document, 29 pages, and I'm really hoping to stream when we're done this one. I'm really wanting to stream the Michelle Troconis trial, and this is about missing mother Jennifer Dulos. So let's get into this here. So the Commonwealth of Massachusetts is the plaintiff versus Karen Reed, the defendant. Defendant motion for recusal and disqualification of Justice Beverly Cannone. Douglas, no. Now comes the defendant, Karen Reed, or Miss Reed, the defendant. You're funny. Keep it chit-chatting. By and through her counsel of record, Worksman, Jackson, and Quinn LLP, and respectfully files the instant request for the recusal and or disqualification of Justice Beverly Cannone. The defense has uncovered disturbing extrajudicial statements by family members of the material witness in this case, alluding to their family's personal connection and ability to influence Justice Cannone. Let me just, sorry guys, I gotta deal with this. Okay. Oh, lordy, lordy, lordy. The defense has uncovered disturbing extrajudicial statements by family members of the material witness in this case, alluding to the family's personal connection and ability to influence Justice Cannone. Okay. Which, when viewed in light of recent procedural irregularities engaged in by this court, to the great detriment of Miss Reed, undetermined public confidence in the outcome of these proceedings, and create the appearance of partiality such that a reasonable, disinterested observer might question whether Justice Cannone can be fair and impartial in this case, and requiring her recusal and or disqualification. The instant motion is based on the information set forth herein and supporting declarations filed here within, and is made pursuant to the Due Process Clause, the 14th Amendment of the of the United States Constitution, Article 29 of the Massachusetts Constitution, Declaration of Rights, and various provisions of the Supreme Judicial. Sometimes, you know what, guys, this is like one hell of a tongue twister when I'm reading some of these. Okay, so the Court Code of Judicial Conduct, which mandate disqualification when a judge cannot be fair or impartial, or where her impartiality might reasonably be requested by a disinterested third party. This motion was timely filed pre-trial upon discovery of the facts and information given rise to this motion in advance of any further proceedings before the court. The prosecution of an accused's right to an impartial adjudicator is deeply enshrined in both the United States and Massachusetts constitutions. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. It's the right of every citizen to be tried by judges as free, impartial, and independent, and lot of humanity will admit. In keeping with that precept, the rules governing disqualification of judges are codified in the Code of Judicial Conduct that gives their rules, which mandates the disqualification, not their rules, but basically what is it called? This when they're using their previous rulings. So the judge cannot be impartial, or the judge's impartiality might reasonably be questioned. Actual impartiality alone is not enough. Our decision and those of the Supreme Judicial Court have commented, and in a variety of contexts, on the importance of maintaining not only fairness, but also appearances of fairness in every judicial proceeding. In other words, an accused constitutional right to due process demands that justice satisfy the appearance of justice, setting aside the issue of whether Justice Cannone has the ability to be fair in this case. The appearance of justice has already been irreparably compromised in this case. Ms. Reed stands charged with the following crimes arising out of the passing of her late boyfriend, John O'Keefe, and in the second degree in violation of, and then it gives the code, manslaughter while under the influence of alcohol in violation, and then the code, and leaving the scene of a personal injury and death in violation of, and then it gives its example, as set forth herein. The following facts and circumstances attendant to this case provide more than a reasonable basis for a knowledgeable, disinterested member of the public to doubt Justice Cannone's ability to be fair and impartial in this case, requiring her disqualification. 1. Sean McCabe, a family member of the seminal witness and third-party culprits in this case, whom Miss Reed has publicly accused of unaliving O'Keefe, made extrajudicial statements to a local investigative reporter that his family had a relationship with Justice Cannone, and the ability to influence her. 2. Justice Cannone has routinely refused to rule in a timely manner on defense motions while advancing and prioritizing motions filed by the Commonwealth and the very witnesses who have claimed an ability to influence her. What? Justice Cannone denied Miss Reed a full and fair opportunity to be heard on a critical discovery motion requesting records from members of the same family that claimed to have had a relationship with her. And four, Justice Cannone has now indicated through the clerk of court in writing that she intends to deviate from procedure in Norfolk County Superior Court by choosing to keep this case with her so she can rule on the Commonwealth's motion to prohibit extrajudicial statements by the defense in which she and the third party culprits have a personal interest, in spite of the fact that she was reassigned to civil court, and this case is properly heard by the judicial officer currently assigned to the criminal session. As such, Miss Reed's constitutional right to due process and a fair and impartial judge require that Justice Cannone be disqualified from these proceedings. Ole, ole. That's only four. I have to buckle up. I know I was saying I've got that other stream set up after this. And I thought, well, I'm going to have to do this after Richard Allen because I'll be exhausted after watching and streaming the Jennifer Dulos trial. So I'll just keep myself hydrated here and we're good to go. Hey, Tony. Have they done any investigation into O'Keefe? Not saying he's guilty of anything, but maybe he came across something he shouldn't have. Either knows the family or knows the other people involved who are all cops. Judges come across cops a lot. Yeah. Holy, okay, here we go. So a brief recitation of facts relating to this case. Miss Reed sets forth a brief recitation of the facts attendant to this case for the purpose of giving context to the disturbing extrajudicial statements made by Sean McCabe in connection with the case, which support Miss Reed's request for the disqualification of Justice Cannone. At approximately 6 a.m. on January 29th, 2022, John O'Keefe was found dead on the front lawn of a Boston police officer, Brian Albert, a highly trained boxer and fighter with deep familial and personal ties to the Canton Police Department and the Massachusetts Police. So yeah, this goes, guys. There are so many connections here. Oh my God, it is just one major freaking rabbit hole, guys. Okay, so the events that transpired the night before O'Keefe's death on January 29th, 2022 are largely disputed. The evidence incontrovertibly establishes that on the evening of January 2022, the decedent O'Keefe, his girlfriend Karen Reed, Brian Albert, Nicole Albert, Jennifer McCabe, which is Brian Albert's sister-in-law and friend of O'Keefe, so the victim. Matthew McCabe and several other individuals met and enjoyed drinks at the Waterfall Bar and Grill in Canton, Mass. As the bar was closing around midnight, The parties discussed going to Nicole and Brian Albert's residence, located close by at 34 Fairview Road, to continue the party and celebrate their son, Brian Albert Jr.'s birthday. Although O'Keefe and Miss Reed were not well acquainted with the Alberts, the invite was extended to them by O'Keefe's longtime friend, Jennifer McCabe. Shortly after midnight, the Alberts, Brian, Nicole, and Caitlin, the McCabes, Jennifer and Matthew, and Brian Higgins, who is a close friend of Brian Alberts and federal agent with the Massachusetts Bureau of Alcohol, Tobacco, Firearms, and Booms, with an office inside Canton Police Department. So, yeah, there's cops everywhere. Okay, so they left the bar in their respective vehicles and drove to Albert's residence for the after party. Witnesses gave conflicting accounts regarding whether O'Keefe actually exited the vehicle and made his way to the Albert residence on January 29th, 2022. Miss Reed maintains that she dropped O'Keefe off at Brian Albert's, located at 34 Fairview Road, just after midnight on January 22nd, 2022, and frustratedly left without him when he failed to answer any of her calls, presuming that he had proceeded into the house for the party. Conversely, the Alberts and the McCabes have maintained that O'Keefe never entered the Albert residence. So this is like a big what? So there's obviously, there's always obviously something wrong with this picture, and I don't know if we're going to get through it here, but his phone, he had an Apple, I do believe an iPhone. I can't remember which version, but you know how they do. It was tracking steps, which I find really, really interesting. They're saying that she backed over him or something along those lines, like ran him over. But somehow he ended up allegedly about 12 feet from where the road was, just there. There's nothing that shows any kind of accident. I mean, all the typical injuries, because, it's usually the legs, right? He doesn't have them, but he does have something, and they're debating, is it dog bites or is it from being backed over? Well, I've never been backed over, but I've been bit a few times. And, we just had the dog bite expert, and everything he showed and said, this guy was bit by a dog. Okay, so the theory advanced by the Commonwealth in support of the filing of the instant charges against Miss Reed is that she became suddenly angry at O'Keefe outside the home of Boston police officer Brian Albert, placed her car into reverse, struck O'Keefe with her vehicle at about 27 miles per hour, shattered the right taillight on her vehicle before fleeing the scene. And I mean, they're saying, what, she just left him in a cop's yard? Good God, Martha. So, however, the photographs of O'Keefe's injuries, which are attached as Exhibit A, now I don't know if we'll see those through here, speak for themselves and are completely inconsistent with the Commonwealth's theory of the case. Photographic evidence of the injuries in the case clearly suggests O'Keefe was beaten severely and left to pass away, having sustained blunt force injuries to both sides of his face as well as the back of his head. So what are they trying to say? You got wrapped up in a tire like a rock does? Give me a break. This I have a very, very hard time with this because a lot of things that they're saying makes no sense. It clashes with common sense. Like common sense will tell you one thing, and yeah. Oh, have you, Tony? That's interesting. But sorry, buddy. Yeah, yeah. Like it's unreal. It really is unreal. It doesn't. How do they say it? The math ain't mathin'. Okay. Okay. Moreover, in addition to suffering numerous defense wounds on his hands, consistent with a brutal fight, O'Keefe also suffered a cluster of deep scratches and puncture wounds to his right upper arm and forearm, which appear to be consistent with a bite and or claw from an animal and are clearly inconsistent with vehicular homicide. Indeed, significant circumstantial evidence suggests that Brian Albert's canine German Shepherd Chloe was actually responsible for the injuries to O'Keefe's right arm, although Brian Albert's attorney made representations in court in filing false, claiming that Mr. Albert's dog Chloe had no history of attacking human beings. Well, we know that wrong. Newly obtained records from the Canton Animal Control and the Canton Town Clerk established that counsel's representations to the public in this court were false. In fact, records obtained from the Canton Town Clerk established that Brian Albert's canine, German Shepherd Chloe, escaped the Alberts residence within mere months after O'Keefe's death and attacked not one, but two separate people. One woman was bitten on the arms and neck. Oh my God, that's scary-ish because these dogs are powerful. So, bitten on the arms, neck, and leg in broad daylight. The other woman was bitten on the left hand. Both victims were taken to the hospital for treatment as a result from the German Shepherd's vicious attack. As set forth in lengthy prior court filings, Miss Reed has also unearthed shocking evidence implicating third parties, Jennifer McCabe and Brian Albert, in O'Keefe's death. Indeed, the analysis of the complete forensic image of Jennifer McCabe's cell phone by computer forensic expert Richard Green, which the Massachusetts State Police and Norfolk County District Attorney's Office withheld from the defense for more than a year. So, you know, I'm getting really confused with this case. I thought that they had to, I thought they had to share all the information. Do they not have to share records and everything with each other? Or am I mistaken? You know, I'm really not understanding why they're having to beg for the basics. Chloe's had a rap sheet. Okay, so let's see here. So, with the Massachusetts State Police and Norfolk County District's Attorney's Office withheld from defense for more than a year, establishes that Jennifer McCabe, one of the Commonwealth's seminal witnesses, Googled "Hoss long to die in cold" at 2:27 a.m. on January 29th, 2022, 3 hours before she supposedly discovered O'Keefe's hypothermic body in the cold snow on her brother-in-law's front yard. Miss McCabe subsequently took steps to purge this research from her phone before turning it over to law enforcement 3 days later. The revelations from Jennifer McCabe's cell phone alone make Jennifer McCabe and Brian Albert prime suspects in this case. This is just the tip of the iceberg. Significant other evidence, too lengthy to discuss here, further implicate Jennifer McCabe and Brian Albert in O'Keefe's deleting. So we also have to remember all this stuff that's floating around here, all this ish in the background, has actually set off a federal probe into how this case has been handled. Now, whether or not we'll see how it turns out. But the fact that they're doing that alone makes me put weight into a lot of this. They don't just go scoping out cases for no reason. Okay, so regardless, Miss Reed's defense is clearly predicated on a third-party culpability defense in which Miss Reed will and has presented significant evidence to establish that Jennifer McCabe and Brian Albert are implicated in O'Keefe's deleting. Suffice it to say that the appearance of ties between Justice Cannone and the Alberts and McCabe families would undermine public confidence in the outcome of these proceedings and would violate Miss Reed's constitutional right to due process and a fair trial by an impartial judge. You know, these places, I mean, everybody knows everybody in a lot of these cases. And I honestly think that if you are in the position that you know anything firsthand about anyone involved in this case, should kind of remove themselves. It only makes sense in my mind. Recent claims by a member of the McCabe family that they are connected to Justice Cannone and can influence her decision in this proceedings. So, May 28th, 2023, Jennifer McCabe's brother-in-law, Sean McCabe, made some extremely disturbing statements to a local investigative reporter, insinuating that he has a close-knit relationship with Justice Beverly Cannone and an alarming ability to influence her decision making in this case. It's just like, what? Adian Kearney. So this is the guy they call Turtle Boy, also known as Clarence Woods Emerson. Not sure what that's about. And Turtle Boy is a local investigative blogger in Boston who, much to the dismay of Brian Albert and Jennifer McCabe, has reported significantly on this case, nearly 70 blog posts to date, and published numerous articles opining that Miss Reed was framed for O'Keefe's deleting by the McCabes and Alberts. A true and correct copy of Facebook messages exchanged between Mr. Kearney and Sean McCabe, Matthew McCabe's brother, and Jennifer McCabe's brother-in-law between May 26, 2023 and June 1st, 2023 are attached here too as Exhibit 1. Not sure if it's attached. Whoa. Sorry, guys. I got to stretch. My body's doing what my body does. Fibro's a biatch. Okay, there. I am going to do this. Just seems like the best option for everybody right now. And let's see here. So that's a name I'm just starting to learn about. Turtle Boy. He has a very large following and a lot of people that are saying that he has done nothing wrong and that he's being set up. So it's another one of those rabbit holes that I haven't personally looked into yet. I need to make up my mind about this crime scene. And then I like to look at some other people's and see if it all kind of fits into what I'm seeing. But yeah, I recommend if you want to know ins and outs, check out, I think he's just called Turtle Boy. And then if you want a complete opposite idea, check out Jennifer Coffindoffer. They're battling. And Turtle Boy's locked up. So there's that. Okay, so let's see here. 70 blogs, blog posts to date, and published numerous articles opining that Miss Reed was framed for O'Keefe's deleting by the McCabe's and Alberts. A true, correct copy of Facebook messages exchanged between Mr. Kearney and Sean McCabe, Matthew McCabe's brother, and Jennifer McCabe's brother-in-law between May 26, 2023 and June 1st, 2023 are attached here to Exhibit 1. Throughout the exchange, Sean McCabe repeatedly threatens Mr. Kearney for writing nearly 70 blogs, posts about the case, and for okay, I'm not sure what this means, alia, exposing connections between members of the McCabe and Alberts family and the lead detective assigned to investigate this case, Massachusetts State Trooper Michael Proctor. Okay. However, on May 27, 2023, Sean McCabe took his threats and taunts a step further and began intimidating that that his family had a relationship with Justice Cannone, the justice actively assigned to Miss Reed's case in May 2023. Indeed, on May 27, 2023, Sean McCabe posted a public comment on Clarence Woods Immersion's Facebook page, which has nearly 30,000 followers, stating, I just called in an order asking Judge Bev to institute a trial by combat order against you. They'll be coming to bring you to me any minute now, Clarence. What? Mr. Kearney took a screenshot of Sean McCabe's comment and sent it to him privately on Facebook, asking, do you really have a line to the judge? The next day, May 28th, 2023, Sean McCabe, knowing full well that he was speaking to an investigative reporter, unabashedly responded, Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under? What? What the mofo, guys? Really? Auntie Bev? So thus, in the same breath that Sean McCabe threatened to delete a local investigative reporter because he was unhappy with the bad press coverage his family had been receiving. He refers to Justice Cannone as being part of the McCabe family and basically says personal knowledge about the location of her home and that only someone close to her would know this information. Wow, are you kidding me already? The mere suggestion that the judge assigned to the case is somehow related to and aligned with the same individuals with credible evidence suggests are the actual third-party culprits in this case should be, okay, hold on here. To be clear, Sean McCabe is related to Jennifer McCabe and Brian Albert, and the very families Miss Reed has shown through credible evidence is responsible for O'Keefe's deleting. Just wow. Okay, so moreover, Sean McCabe's insinuation that he and his family have a personal relationship with Justice Cannone is further legitimized by the fact that his threat contains accurate personal identifying information about Justice Cannone that, absent some relationship, would otherwise be unknown to Sean McCabe. Shockingly, it does appear that the seminal witness in the case, i.e., the McCabes and the Alberts, or at the very least their family members, possesses intimate knowledge about Justice Cannone, including the fact that she owns a seaside cottage on Cape Cod. Indeed, as set forth in the attached declaration of Alan Jackson, notarized deeds filed by the Barnstable Registry of Deeds confirm that both Sean McCabe and Justice Cannone own property on the Cape in Centerville, Mass, and live less than 4 miles from each other. Copies of the deeds confirming the same are filed herewith under the order of impoundment. Thus, Sean McCabe's suggestion that he has a relationship or connection with the judge or with Judge Cannone appears to at least be factually credible, given that they both own homes in a small town on the Cape, less than 4 miles apart. I've never been to Cape Cod, so I don't really know what's going on as far as how close properties are, and a lot of areas that I've lived in, places are distant, but we didn't know each other. But I don't know. This case is sus AF. That's really all I know. Sharknado. I don't know what that is. Okay, there are only two reasonable explanations as to why Sean McCabe would know that Justice Cannone owns a seaside cottage. One, Sean McCabe either knows Justice Cannone or has crossed paths with Justice Cannone on the Cape. Or two, the McCabes have taken steps to locate and obtain personal identifying information about the judge presiding over the case and communicated that knowledge publicly for the purpose of intimidation. Fair? That's a Sharknado. All right. So this threat was not limited to Mr. Kearney. Rather, Sean McCabe sent this message to Mr. Kearney, knowing full well Mr. Kearney is an investigative reporter and has, and sorry, investigative reporter, and his conversations and comments about Justice Cannone would be widely publicized. And does he have credentials, guys? This I don't know. On Mr. Kearney's website, in fact, at the very start of the conversation with Mr. Kearney, Mr. McCabe encourages Mr. Kearney to publicly share their conversation on his website, writing, "So if you want to talk to me, you're going to hear what I have to say first. Cut the paste, cut and paste this shit all, all you want, Sally, but you don't have the stones to look me in the eye." Thus, Sean McCabe's threat to delete Mr. Kearney and bury him under Auntie Bev's seaside cottage was meant to suggest to Miss Reed that the public at large, Justice Cannone, is family. She will back our play. You know, and that sadly does happen in some areas, doesn't it? It's a very sad thing. Okay, let me do a little check in here. Let me see. Okay, let me check it out. Well, that's just fine. Okay, so as set forth in further detail below, whether it be out of fear, intimidation, relationship, or for some other reason, significant procedural irregularities engaged by Justice Cannone have prejudiced, misread, and benefited the Alberts and McCabe's, such that any disinteresting third party would have to question Justice Cannone's impartiality in this case. So something else I want to say, you know what? Usually I'm like, oh, they're guilty. Like, look at that. They're guilty. I'm not doing that with this case. Are you guys? Like, it's the mouth ain't mouthing. The mouth ain't mouthing. Facts relating to the procedural history of this case. Miss Reed has engaged in significant pretrial litigation with the Commonwealth in an effort to obtain additional critical discovery, which will further implicate the McCabes and or Alberts in O'Keefe's deleting, notwithstanding any issues relating to the substance of the court's ruling. Justice Cannone has subsequently and increasingly delayed her decisions on motions filed by the defense and denied Miss Reed a full and fair opportunity to be heard. A brief summary of the procedural history in the case as it relates to those claims is detailed below. Oh my God, guys. Chit chat, chit chat. I need to get some more liquids. What do you guys think about this? Tell me. Oh, what do you think? Innocent or don't know enough? Sorry, friends. Isn't there a lot of names, Tony? There really is. There is a lot of cops, a lot of cops' family. I mean, it was a get together after the bar. So March 12th. I have a hard time seeing her as guilty. Just my opinion. You know me. Okay, so May 3rd hearing. Miss Reed, through her counsel, timely filed 3 significant discovery motions. There you go. In advance of the May 3rd, 2023 pretrial hearing scheduled in this case. All of these motions were targeted at uncovering additional evidence, which law enforcement has neglected to obtain during the course of their investigation. And Miss Reed had reason to believe would exculp, there we go, her would prove her innocence and implicate the McCabe's and Alberts in O'Keefe's death. First, on February 2nd, 2023, Miss Reed filed a motion for order pursuant to Mass R and now go, directed to Canton Animal Control and the Canton Town Clerk, and a motion for the animal control records, requesting records and information concerning a violent skin piercing incident involving Brian Albert's canine German Shepherd and his hasty decision to rehome the dog just months after O'Keefe's passing. Subsequently, on April 12, 2023, defendant Karen Reed filed a motion for order pursuant to Verizon and AT&T, requesting Jennifer McCabe and Brian Albert's cell phone records during the relevant period, along with any cell phones belonging to Brian Albert for the same period. Finally, on April 6th, 26th, I guess do that one again. On April 26, 2023, Ms. Reed filed defendant's renewal motion to compel discovery. Affidavit of David R. Yannetti in support of defendant's renewal. Renewal motion to compel discovery with certificate of service and supporting exhibits. A request defense access for critical items of evidence that have and continue to be withheld by the Commonwealth and the court imposed dates. See, this is the thing, like why they are fighting every tiny little bit, and it's not a good look. We watched the other day what was happening there, and it's just like, are you kidding me already? On May 2nd, 2023, the day before the hearing was set to take place, the Commonwealth filed its opposition to defendant's motion pursuant to Rule 17, and the Rule 17 is important in this case, of criminal procedure, production of records from Canton Animal Control and the Canton Clerk's Office, and its memorandum in opposition to defendant's motion pursuant to Rule 17 of criminal procedure. At the hearing, these documents are, you can probably find them. I might see if I can. I'll see if I can link them in Discord. That's probably my best bet. Okay. At the hearing, Brian Albert by and through counsel. Of record, Gregory Henning also filed an opposition to defendant's Rule 17 motion for cellular device records. They're fighting even the cell phones, like literally. On May 3rd, 2023 at 2 p.m., this court held a widely publicized pretrial hearing, which was covered by national and local news media outlets. At the hearing, the court heard argument on the motion for animal control records and the renewed motion to compel, but reserved ruling on both motions. The parties agreed to defer argument of the Rule 17 for cell records until a later hearing. Like, why is she having to fight for these damn cell records? I mean, the prosecution has them. Okay, so let's see here. So yeah, they agreed to defer the argument, Rule 17 motion for cell records until a later date because the issues arised in the motion involved significant factual disputes, which would need to be resolved through an evidentiary hearing. And the court rearranged its schedule a bit so that we could accommodate you. Because the Commonwealth objects, because the Commonwealth's objections to the defendant's Rule 17 motion were merely born out of factual disputes. This court set an evidentiary hearing for May 25th, 2027, and ordered the parties argue the merits of the motions for cell records that day. The court received the ruling on the defendant's motion for animal control records and the renewed motion to compel, and clearly set this case for an evidentiary hearing on May 25th, 2023 at 9:30 a.m. In spite of the fact that the hearings on the motion for animal control records was heard and argued on May 3rd, 2023, it took Justice Cannone 16 days to finally issue her ruling, allowing defendants' request for animal records. Indeed, on May 19th, 2023, Justice Cannone allowed the motion and issued an order for the production of the records from Canton Animal Control contained exculpatory evidence or information, which substantiated Ms. Reed's third-party culpability defense and further tied Brian Albert to O'Keefe's passing. Since then, Justice Cannone's rulings have become increasingly dilatory. To date, it has been 72 days since the May 3rd hearing, and in spite of reminders to the court's clerk, Ms. Reed still does not have a decision on the renewal motion to compel. In addition to this court's apparent refusal to rule on properly noticed motions before the court, Justice Cannone has denied Ms. Reed the ability to be heard. I don't know, like none of this is looking good for the judge. That's all I have to say. But I think we might be surprised. I think I got an idea how this story goes. Mm-hmm. Let me see here. So, yeah, that's a good question. Then why would a bunch of experienced cops just place a dead body outside their property? So, yeah, good question. You would think they'd do a better job of covering it up unless they knew someone like Karen would be around looking for him at that location. Maybe they all knew the girlfriend was drunk and I could easily pin it on her. Yeah, you guys have some great thoughts. Absolutely great thoughts. Okay, hang on here. Maybe I need bigger glasses, more stronger, because oh my God, my eyes get so tired so fast. I'm getting close to those rust years. Okay. Two, the court's decision to completely vacate the May 25th hearing on the Rule 17 motion for sell records without notice to the defendant. Oh no. Oh no. So what? We'll have to see. Is this judge headed where Judge Gull is headed is right now? Is this where this girl's going? As detailed above, this court and the respective parties agreed to set the instant case for an evidentiary hearing on May 25th, 2023, to resolve factual disputes related to Defendant's Rule 17 motion for sell records. Ms. Reed expended significant funds subpoenaing witnesses in preparation for the hearing, including Brian Albert and Jennifer McCabe, and the Commonwealth's computer forensic expert, Trooper Guarino, flying in and out of state experts to testify regarding his findings on Jennifer McCabe's cell. It's a good thing this woman's got money, because if she's truly innocent, this is costly. This is really costly. I'm gonna come see that. I rewatched the video of her backing into the car and she did hit it. The car does move. Are you serious? Okay, I'm gonna look at that again, Tony, because maybe I just need to take a closer look, because I believe you. The state of Indiana has put a motion to amend Richard Allen's charges. What? Are you serious? Oh my God. Alrighty. So it says, however, on May 22nd, 2023, 3 days before the scheduled hearing, without any advance notice to Miss Reed or her counsel, the find a full screen video of it. Are you serious? What? Oh, I'll be looking into that. I'm good friends with an ex-female leading detective who quit 3 years ago. She tells me the state cops are more corrupt than you can imagine. Oh, that's the thing. I mean, it's not unheard of, is it? It's not unheard of. Okay, so however, on May 22nd, 2023, 3 days before the scheduled hearing, without any advance notice to Miss Reed or his counsel, the Commonwealth, Brian Albert, and Jennifer McCabe, clearly acting in concert, filed a flurry of motions requesting inter alia that the evidentiary hearing set for May 25th, 2023, suddenly be canceled. At least it's not sketchy, you know. What? Mexi, I'll be looking into that, friend. That's just what? Specifically on May 22nd, 2023, Brian Albert and Jennifer McCabe both filed motions to quash the subpoenas which had been served on them by Miss Reed's counsel to testify at an evidentiary hearing. The same day, the Commonwealth, in a shocking reversal of its position with respect to the evidentiary hearing, it previously asked be put on the calendar, filed in opposition to defendant's request for evidentiary hearing on Mass R. Shortly after, Brian Albert's counsel emailed the court's clerk requesting that the hearing on the motions to quash be advanced to a date before May 25th hearing. After coordinating schedules, the clerk set the case for a hearing on the motions to quash on May 24th, 2023, and indicated that Justice Cannone wanted to address the Commonwealth's motion at least initially. Thus, the court then set a hearing on May 24th, 2023 to determine whether the motion to quash should be granted and to hear at least initially the Commonwealth's opposition to defendant's request for evidentiary hearing. So why are they having to fight for evidence, guys? Like, someone help me here. What? So thus the court then set a hearing for May 24th, 2023 to determine whether the motions to quash should be granted to hear at least initially the Commonwealth's opposition to defendant's request for evidentiary hearing, which ironically was agreed by the Commonwealth in the first place. Notably, Rule 17 motion for cell records and evidentiary hearings were still scheduled to be heard May 25th, 2023. Upon hearing in court for the May 24th hearing, the court heard arguments regarding the motions to quash the subpoenas served on Brian Albert and Jennifer McCabe, and while sitting on the bench, allowed both motions, precluding Miss Reed from calling them to testify at the evidentiary hearing. The court then heard argument with regard to the Commonwealth's opposition to counsel the evidentiary hearing in total, which was clearly both necessary and appropriate because, as the Commonwealth argued later during that hearing, the Commonwealth disputed nearly every evidence-based assertion set forth by the defense in defense in the Rule 17 motion for cell records, including whether Jennifer McCabe Googled "Hoss long to die in cold" at 2:27 a.m. Well, yeah, hours before she claimed to have found O'Keefe's hypothermic body in the snow of her brother-in-law's front yard. Immediately following the argument, the court quickly issued a ruling allowing Commonwealth's motion to cancel the evidentiary hearing, adopting the Commonwealth's legally incorrect theory that there was no authority for it, and effectively denied Miss Reed the ability to prove that the disputed facts set forth in her Rule 17 motion for cell records were, my eyes are crossing, in fact true. Therefore, the court then announced to counsel that she would hear argument on the Rule 17 motion for cell records. Ms. Reed and her counsel never notified that there was even a remote possibility that the Rule 17 motion for the cell records was going to be heard that day. Gosh. Gosh, guys. So what do you think? Like, yeah, shouldn't they be getting these documents? Isn't that just normal procedure that you, why is there so much secrecy to what was happening on these phones in that house when this happened? Why are they having to fight what I would assume should just be automatically given to the defense? When are people going to learn not to search certain things on Google? Hmm. So let's see here. The court has now made the unilateral decision to deviate from the procedure and to prevent the criminal session judge from hearing the Commonwealth's motion to gag Miss Reed's attorneys. Oh, okay. On June 9th, 2023, the Commonwealth filed a motion to prohibit prejudicial extrajudicial statements of counsel in compliance with Massachusetts rule of professional conduct, motion for gag order, requesting that the defense counsel for Miss Reed be gagged and prohibited from making any statements about this case whatsoever to the press. The Commonwealth's motion for the gag order was noticed July 25th, 2023, and was requested to be heard the next pretrial hearing, which was already on the calendar in this case. June 15th, 2023, a mere 6 days after receiving the motion for gag order, counsel for Miss Reed received an email from Mr. McDermott with the Suffolk Superior Court stating, the court needs a response to the Commonwealth's motion to prohibit extrajudicial statements. The clerk further indicated that Justice Cannone wanted to unilaterally advance the hearing on the motion for gag order, which was properly noticed for July 25th to June 27th or June 28th. Notably, on the same day, Justice Cannone sought to advance the hearing on the Commonwealth's motion for a gag order, which clearly benefited Brian Albert and Jennifer McCabe. She still had not ruled on Miss Reed's Rule 17 motion for cell records, which had been under advisement for 22 days. Hello, Dandy. Oh, my word. When counsel for Miss Reed pushed back and indicated that our office would need time to respond to the motion for gag order, intended to appear in person, and were unavailable on the dates proposed by the court, Justice Cannone indicated through her court clerk that her efforts to advance the hearing was done because she was looking to hear this while she was sitting in a criminal session. Thus, because the defense was defense requested to have the motion heard on the date that was already on calendar and the date noticed and Attorney Lally motion, the court indicated through her court clerk that she would hear the motion for gag order on July 25th in a civil session rather than have the criminal session hear this. Notably, the press and court of public opinion have not been friendly to Justice Cannone, Jennifer McCabe, or Brian Albert. Notably, Justice Daniel J. O'Shea is currently assigned to the criminal session and appears listed on the docket, the justice assigned to this case. Oh, my word. Hello, hello, hello. I have to shake my head. Give my head a shake, guys. This is crazy. Did you find the leak, Dandy? Good, 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 good. You didn't get a notification. YouTube is, yeah, I don't know, not as reliable as I'd like to have them, right? So I mean, there's free Karen Reed all over the place. It's not looking good for the state right now. I really have to say. The more I learn, the more I'm asking questions. It's like, what are you trying to say? What? My God. Oh my God. Mm, 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 mm. Let's see here. Where was I? Uh, 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 uh. So court indicated to her clerk that she would hear motion for gag order July 25th. The press have not been friendly. Okay. Indeed, the public already lost confidence in the court's ability to be fair and impartial in this case. Fair enough. Attached here too for the court's review, Exhibit J, are examples of comments culled from various articles about this case published by local and national news outlets, culled from various, all of which established that the regular disinterested people following this case are already questioning Judge Cannone's ability to be fair in this case. So the argument, it's an axiomatic that a fair trial in a fair tribunal is a basic requirement in the due process. Not only is it a biased decision maker constitutionally unacceptable, but our system of law has already endeavored to prevent even the probability of unfairness in pursuit of this end. Various situations have been identified in which experience teaches that the probability of actual bias on the part of the judge is too high to be constitutionally tolerable. Among those cases are those in which the adjudicator has a pecuniary interest in the outcome and in which he has been the target of personal abuse and criticism from the party before him. Well, this is just like the most sus thing ever. Like, come on. Of course, people are looking. What? That's pretty much what I'm thinking. Moreover, as the United States Supreme Court has explained, our system has an obligation to do more than simply protect against proven bias and unfairness on the part of the judge. Rather, justice must satisfy the appearance of justice. Therefore, every procedure which would offer a possible temptation to the average man as a judge to forget the burden of proof required to convict the defendant, or which might lead him not to hold the balance nice, clear, and true between the state and the accused denies the latter due process of law. So important in this in the appearance of fairness, that it may require a judge to disqualify herself, even though she has no actual bias or prejudice, and would in fact do her very best to weigh the scales of justice equally. So I don't know. Should she recuse herself? The same guideline principle of impartial justice is also expressly enshrined in Article 29 of the Massachusetts Constitutional Declaration of Rights. It is essential to preserve, it is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. A rigid adherence to that principle is essential to the maintenance of free institutions. It may never be relaxed. Article 29 is at least a rigorous and exacting high standards of judicial propriety, as the due process clause of the 14th Amendment. Thus, the protection of the accused's rights to have an impartial adjudicator is deeply enshrined in both the United States and Massachusetts. Well, that's just common sense, right? Like, isn't that just common sense? The Massachusetts Code of Judicial Conduct similarly recognizes that an independent, fair, and impartial judiciary is indispensable to our justice system. In keeping with these precepts, the rules governing disqualification of judges are codified in the Code of Judicial Conduct. A judge shall disqualify himself or herself in the proceeding in which the judge cannot be impartial or the judge's impartiality might reasonably be questioned. I would have to say that's definitely there. Oh, okay. Thus, the ethical rules provided that a judge must be disqualified unless the judge can satisfy both a subjective and objective standard of impartiality. The subjective standard requires disqualification if the judge concludes that he or she cannot be impartial. Conversely, the objective standard requires disqualification whenever the judge's impartiality might reasonably be questioned by a fully informed, disinterested observer, regardless of whether any of the specific provisions mandating disqualifications apply. Thus, in reaching a determination on the motion for disqualification, judges must follow a two-pronged test. First, in ruling on the motion to seek recusal, a judge must consult first her own emotions and conscience. If she cannot satisfy this subjective standard, then the judge must recuse herself. Yeah. I mean, guys, isn't this just kind of basically common sense? I wouldn't want a judge that doesn't like me. Being the one that charges me, that doesn't sound like a good idea at all. I've actually seen it happen in a small town, and it wasn't pretty. The guy was dating the judge's daughter, and he did some ish. He just didn't like the daughter's girlfriend, and oh yeah, he ended up in the Huskow. Yeah, he went hard. Okay, let's see, where are we? If the judge determines that she cannot be impartial or that her impartiality in the case might reasonably be questioned by any objective juror, then the judge is ethically required to recuse herself. Furthermore, a judge is ethically required to disclose on the record information that the judge believes the parties or the lawyers might have reasonably consider relevant to the possible motion for disqualification, even if the judge believes there is no basis for disqualification. As set forth below, Ms. Reed cannot and will not speculate as to whether Justice Beverly Cannone can be subjectively impartial in the case. However, Ms. Reed is on trial for her life. The suggestion is this a DP? I didn't realize this was DP, guys. Ten more pages. Okay, so, but by a family member, third, as set forth below. However, Miss Reed is on trial for her life. This suggestion, not by okay. So it says that they have a relationship with the ability to influence Justice Cannone, when considered in light of the significant procedural irregularities that have inured to Miss Reed's great detriment and to the benefit of Jennifer McCabe and Brian Albert. Cast a shadow over the case so large and any disinterested third party would have to question Justice Cannone's impartiality in the case, in point of fact, they already have. Thus, as set forth below, Miss Reed respectively requests that Justice Beverly Cannone disqualify herself from the proceedings. You guys, go back and look, and if I can find it, I'll put it out there. But we want to see if that car bumps when she is backing up. Because if that car bumps, well, that explains everything, doesn't it? Okay, if this court believes she cannot be impartial in this case, then she must recuse herself. First, as explained above, under the subjective standard and disqualification set forth in Supreme Judicial Court Rule 211, a judge is required to recuse herself if she cannot be impartial. Thus, the court must endeavor to consult first her own emotions and conscience to determine whether she can be fair and impartial. If the court subjectively believes she can no longer be fair and impartial, she must recuse herself. Although Ms. Reed will not speculate as to whether Ms. Cannone can be subjectively be fair and impartial in this case, she requests that this court consult her emotions and conscience to determine whether recusal is required on this ground. Why is this judge even there? If she knows all these people, you gotta go, friend. You gotta go. I don't think this girl, this lady, I don't think she's getting treated right. I have not seen one thing that has proved guilt with her. I'm sorry. I have not yet. Personal opinion. We can all make our own. I'm not preaching. I'm just saying my opinion. And everybody in a case like this is going to have their very own thoughts on the matter. And that's just the way it is. So, yeah, all opinions are equally welcomed. So, the fact and circumstances attendant to this case clearly suggest that an objective, disinterested observer might reasonably question Justice Cannone's impartiality in this case, necessitating her disqualification. regardless of whether the court subjectively believes that she can be fair and impartial. The state and federal constitutions and Massachusetts Code of Judicial Conduct require that the judge disqualify herself where her impartiality might reasonably be questioned, and it's reasonably questioned. Actually, impartiality alone is not enough. Our decision and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness, but the appearance of fairness in every judicial proceeding. Yeah. In order to preserve and protect integrity of the judiciary and the judicial process and the necessary public confidence in both, even the appearance of partiality must be avoided. The Code of Judicial Conduct sets forth 5 non-exhaustive circumstances explicitly necessitating disqualification, which include the following. The judge has personal bias or prejudice about the party or the party's lawyer. That's what's happening as far as I'm concerned, that's what's happening in the Richard Allen case. Or personal knowledge of facts that are in dispute of the proceeding. The judge knows that the judge's spouse or domestic partner, or a person within the 3rd degree of relationships to either of them, or the spouse or domestic party of such person is a party to the proceeding, or an officer, director, general partner, managing member, or trustee of the party, acting as a lawyer in the proceedings. A person who has more than, Latin, de minimis? De minimis? What does that mean, Max? De minimis. Financial or other interests that could be substantially affected by the proceedings, or likely to be a material witness in the proceedings. The judge, now that he or she individually or as fiduciary. You know what? Like, oh my God, I think I'm doing not too bad for legal jargon, but every once in a while my tongue doesn't want to do it. De minimis to rival or minor to merit consideration, especially in law de minimis fringe benefit rules. Thank you, my brilliant friend. Okay, let's see here. The judge, while a judge or judicial applicant or judicial nominee has made a public statement other than in a court proceeding, judicial decision, or opinion that commits or appears to commit that the judge to reach a particular result or rule in a particular way in the proceeding or controversy. The judge served as a lawyer in the matter in controversy or was associated with a lawyer who participated, subsequently a lawyer in the matter during such association, served in governmental employment, and in such capacity participated personally and substantially as a lawyer or public official concerning the proceedings, or has publicly expressed in such capacity an opinion concerning the merits or the particular matter in controversy, was a material witness concerning the matter, or previously presided as a judge over the matter in another court. However, this list is non-exhaustive, and the objective standard mandates disqualification whenever the judge's impartiality might reasonably be questioned by a fully informed, disinterested observer, regardless of whether any of the 5 examples set forth or are at issue. Sean McCabe's public comments alone require disqualification. As explained above, in order to protect public confidence in the judiciary, it is not enough to prevent actual bias. Rather, even the appearance of partiality must be avoided. Here, the appearance of partiality cannot be avoided because Sean McCabe, a family member of the very individuals Miss Reed's third-party culpability defense is predicated on, has claimed that his family has a relationship with Justice Cannone and has the ability to influence her decision making. Indeed, the court's failure to disqualify herself based on Mr. McCabe's claims alone would fly in the face of numerous rules set forth in the Code of Judicial Conduct, which are meant to protect erosion of public confidence in the impartiality of the judiciary and additional to rule, which requires disqualification of a judge where her impartiality might reasonably be questioned. Similarly, requires that a judge act on all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety, shall not convey or permit others to convey the impression that any person or organization is in the position to influence a judge. In exceptional circumstances like this, where a third-party culprit's family member is openly threatening an investigative reporter by claiming a relationship with the judge that is responsible for deciding whether the family members' privacy interests outweigh a criminal defendant's right to defend herself in a deleting case. This creates the appearance of impropriety and partiality. Here, Sean McCabe responded to a direct question about whether he has the ability to influence Justice Cannone in reference to this case, with a threat that relayed personal information about the judge, namely Auntie Bev, whose seaside cottage do you think we're going to bury your corpse under? Huh. Whose sea? Oh my God. This statement was clearly meant to convey the impression that his family knows the judge and is in a position to influence her. Moreover, this suggestion is further corroborated by the fact that the threat contains accurate personal identifying information about Judge Cannone that absent someone relationship would otherwise be known to Sean McCabe. They're saying that, yeah, why does he know this personal information if they're not buddies? Significantly, the Code of Judicial, regardless of whether Sean McCabe's claims are true or not, these threats clearly provide what an objective, knowledgeable member of the public would find to be reasonable bias for doubting Justice Cannone's impartiality, requesting disqualification. Yeah, it should be a jailable offense, Douglas. Like, what? Failure to perform duties fairly and diligently on motions made by Ms. Reed. Canon 2 of the Supreme Judicial Court's Code of Judicial Conduct requires its judges to perform the duties of judicial office impartially, competently, and diligently. Rule 25, okay. explicitly sets forth that a judge is required to perform judicial and administrative duties competently, diligently, in a timely manner. Indeed, timely disposition of the court's business requires a judge be expeditious in determining matters under advisement and to demonstrate due regard for the rights of parties to be heard and have issues revolving without unnecessary cost or delay. Further, a judge should monitor and supervise cases in ways that reduce or eliminate, I think, derogatory, dilatory practices, avoiding delays and unnecessary costs. The failure of a judge to abide by these basic ethical requirements clearly suggests at least the apparent. Ooh, let me see. I get the weirdest numbers calling me. Okay, so let's see here. Here, without even reaching the substance of the court's ruling in the case, there is no question that for some reason unknown to the defense, Justice Cannone has been dilatory in issuing rulings on the defense motions that are under advisement. With the court's new and escalating practices of delaying her rulings on defense motions, which have already been argued and heard by this court, first by 16 days on Miss Reed's motion for animal control records, then 27 days on Miss Reed's Rule 17 motion for cell records, and in one instance, 72 days on Miss Reed's renewed motion to compel discovery, even in spite of a reminder by counsel that the motion remains under advisement, does not give rise to the appearance of justice and impartiality. No, it does not. Okay, finding clerk magistrate violated rules of professional responsibility and should be removed from office for failing to issue decisions on matters for 30 to 45 days, and would certainly make a reasonable person wonder why the court is suddenly motivated to stall these proceedings and delay Miss Reed's ability to seek and obtain evidence in her case. Yeah, this is a nightmare. If this is all the case, and I mean, it's on a court document, so I tend to believe what's being said. This is bullshit. Personal opinion. Furthermore, this court's significant delays in deciding defense motions under advisement, and in one instance, refusal to rule on Miss Reed's properly noticed renewed motion to compel, clearly appears to be one-sided, as evidenced by the court's recent attempts to unilaterally advance and hasten a decision on a motion filed by the Commonwealth to gag Miss Reed's counsel. Moreover, by failing to rule the renewed motion to compel discovery, Miss Reed is forced to patiently wait with the weight of a false charge hanging over her head in litigation purgatory, unable to access the remainder of her critical evidence she needs in order to prepare her defense, announce ready for trial, or avail herself of any remedies should they be needed on appeal. The objective metrics establishing recent and escalating delays and rulings, as evidenced by the court's own docket alone, clearly provide what an impartial member of the public would find to be reasonable basis for doubting Justice Cannone's impartiality requiring disqualification. Well, this just screams disqualification. It doesn't go, oh, hey, you're the one we need. You're the perfect candidate. Justice Cannone's denial of Miss Reed's ability to be heard indeed is set forth in SJC Rule 2.6. A judge shall accord to every person who has a legal interest in the proceeding or that person's lawyer the right to be heard. As the Supreme Judicial Court has made clear, the right to be heard is an essential component of a fair, impartial system of justice. Substantiative rights of litigants can be protected only if procedures protecting the rights can be heard are observed. In keeping with that precept, a judge's decision to delay a defendant the ability to be heard suggests, again, lack of fairness and impartiality. Here, as set forth in more detail above, Justice Cannone denied Miss Reed a full and fair opportunity to be heard on her Rule 17 motion for cell records relating to Jennifer McCabe and Brian Albert. Why are these being held back? Whose family member, Sean McCabe, has publicly claimed to have a relationship with and the ability to influence Justice Cannone. As detailed above, the court and respective parties agreed to set the instant case for an evidentiary hearing on May 25th, 2023, to resolve factual disputes related to the defendant's Rule 17 motion for cell records. Miss Reed expended significant funds subpoena. She's paying for this, guys. This is coming out of her pocket. So witnesses in preparation for the hearing, including Brian Albert and Jennifer McCabe, and the Commonwealth computer science expert, Trooper, I think it's Garino, flying in and out of the state computer forensic expert to testify regarding his findings on Jennifer McCabe's cell phone and preparing for the examinations of witnesses at the evidentiary hearing that was stipulated to by the parties and placed on a calendar by this court. The court's decision to cancel the May 25th evidentiary hearing, adopting the Commonwealth's legally incorrect theory that there was no authority for it, and effectively denying Miss Reed the ability to prove the disputed facts set forth by her in the Rule 17 motion for cell records, where, in fact, true smacks of partiality towards McCabe's and Albert's. Agreed. By advancing the Commonwealth's untimely motion, filed a mere 3 days before the previous scheduled May 25th, 2023 hearing, to cancel a legally necessary and appropriate evidentiary hearing served only to deny Miss Reed the ability to be heard and present evidence necessary to prove she was entitled to the records sought. The court hasty decision to allow the Commonwealth's motion to cancel the evidentiary hearing while still sitting on the bench and adopt the Commonwealth's legally incorrect theory that there was no authority for it, effectively denied Miss Reed the ability to be heard and proved the disputed facts set out forth in her Rule 17 motion for cell records were in fact true. Yes. I mean, anybody that was there, they need the records. I don't care if it just bounced off their cell tower. If they're in that vicinity, come on. So thus, Miss Reed's counsel was forced to argue an extraordinarily factually complex and lethal, lethal, could be, to frick, what are these guys trying to do to her? Allegedly, it's just not looking good. And I'm coming into this not knowing a lot. I've just been learning and going based on what I am reading and seeing, and mainly from court documents. So, okay, let's see here. A reasonable, disinterested server would certainly question whether this was done in effort to prevent the defense from having a full and fair opportunity to argue the Rule 17 motion for all cell records in a crowded courtroom the next day, where major national and local news outlets were scheduled to be present and observe the proceedings. Instead, what at least appears to be an attempt to act under cover of darkness, this court advanced the proceedings, denied Ms. Reed's ability to call any witnesses in support of her motion, and forced her counsel to argue a motion that was not properly on the calendar that day. The procedural gamesmanship denying Ms. Reed the ability to be heard, which was facilitated by Justice Cannone on May 24th, 2023, would give any disinterested member of the public a reasonable basis for doubting her impartiality, requiring disqualification. That's fair. Justice Cannone's decision to depart with Norfolk County Superior Court judicial assignments and take the case with her to civil court. Finally, the court's decision to deviate from typical procedure in Norfolk County Superior Court and reassign this case to herself, in spite of the fact that she was reassigned to sit on a civil session so that she can hear the Commonwealth's motion and gag order, which would prohibit the defense from making extrajudicial statements to the press, clearly creates the appearance of partiality. June 15th, 2023, they're a mere 6 days after testimony, 6 days after attorney Lollipop, filed the Commonwealth's motion to gag order. Counsel for Miss Reed received an email from Mr. McDermott with the Norfolk Superior Court stating Justice Cannone needs a response to the Commonwealth's motion to prohibit extrajudicial statements. Thus, Justice Cannone was apparently ignoring the rules of procedure governing the times required for the opposition and was requesting that the defense hurry up and respond to the Commonwealth's motion, which was noticed to be heard a full month later, so that she could hear the motion before she was reassigned to a different courtroom. Notably, on the same day, Justice Cannone sought to advance the hearing on the Commonwealth's motion for gag order, which clearly benefits Brian, Albert, and Jennifer McCabe. She still has not heard. She has still not ruled on Ms. Reed's Rule 17 motion for cell records, which had already been under advisement for 22 days. Yeah, like, I don't know, lady, play fair. You're not going to help this case. Maybe that's the point. Notably, on the same day, Justice Cannone sought to advance the hearing on the Commonwealth's motion for gag order, which clearly benefits. Yep. Okay, 7 for cell records, which had already been under advisement for 22 days. A reasonable person might infer that these actions at least appear to suggest that the judge is partial to one side. Moreover, counsel for Miss Reed informed the court that she would need time to respond to the motion for gag order, intended to appear, and were unavailable on the dates proposed by the court. Justice Cannone indicated through her court clerk that she would exercise supervisory authority to take the case with her to the reassignment in civil court rather than have the properly assigned criminal session judge hearing the Commonwealth's motion for gag. What? This is not, again, this is not making a hell of a lot of sense to me. Sorry, guys, I just have to update something. My streams are, I think I'm going to do this one. I'll do it at 1:30. Nope. Yes, I think that's the way to go. Sorry, guys. We're almost done here. Almost. Okay, so let's see here. Moreover, when counsel for Ms. Reed informed the court that we need time to respond to the motion for gag order intended to appear in person and were unavailable on the dates proposed by the court, Justice Cannone indicated through her clerk that yes. So clearly the totality of the facts in this case, including the threatening statements and claims made by Sean McCabe suggesting a close-knit relationship between the third-party culprits in this case and the judge, the court's recent escalating delays in the rulings on defense motions that are under advisement, the court's denial of Ms. Reed's ability to be heard under her Rule 17 motion for cell records, and her decision to deviate from procedure and keep this case so she can decide the Commonwealth's motion for gag order, in which she quite clearly has a personal interest. In spite of her reassignment to civil court, would give any disinterested member of the public a reasonable basis for doubting her impartiality. As such, Justice Cannone must be disqualified from deciding any further issues of consequence on this matter. Boom. So this was way back in July 14th. And they've been trying to, from what I can see, they've been trying to shut this woman down for a long, long time. So I don't know, guys. What do you think? Do you think this is on the up and up? I have questions. I have a lot of questions. So I'm going to continue putting stuff out on Karen Reed and see if we can find out what is happening behind the scenes. Do we have like a crooked system again? Because we definitely know there are crooked systems. So with that said, thank you again. That was a 2-hour stream. So thank you. So I'm going to set up for 1:30 for my next live, and that's going to be the Michelle Traconis trial with missing mother Jennifer Dulos. So guys, I appreciate you, and I'll see you in the next one.